my experience with Boris, he had kind of, placed himself as close as he could to the president and then done everything he could to make himself the single point of failure so that nobody else could really get close to him. And, I think over the course of years, he kind of worked his way into this position and, really tried to stop anybody else from having any direct contact, with the president except through him. And so, reading the allegations that came out today, I'd like to say that they surprised me, but the reality is that they don't. They maybe surprised me with the scope and the brazenness of it, and the fact that he really does believe that at this point he's gotten to the point where he really is untouchable.
Hello, friends, and welcome back to Highly Conflicted, where we unpack the news inside Trump world and what might be coming down next at Mar-a-Lago. We're now 20 days since the election, and the ramifications of Trump's victory are now being felt at the Justice Department, as Special Counsel Jack Smith, who charged Trump over his retention of classified documents and over his efforts to overturn the 2020 election, moved to dismiss his cases. It effectively marked the end of the years-long legal battles between Trump and the special counsel, and it marked the extraordinary ability of Trump to sidestep some really serious criminal charges. But it also showed just how successfully that Trump, with help from sympathetic judges, managed to beat the justice system with an audacious play of using a presidential campaign and the political calendar to sidestep deeply perilous charges. To get a sense of how Trump legal might be processing the news, or as close as we can get, I'm joined now by Tim Parlatore, who was one of the lead lawyers representing Trump during the investigations and dealt directly with Jack Smith and his team before he resigned from the legal team a few months before the first indictment. Tim, it's great to have you.
Thank you.
So, just God's eye perspective here, what's your initial reaction to the news that Jack Smith is dropping these cases even before Trump is inaugurated? Because once upon a time, there was this sense that Jack Smith might want to power through to January 20 and see as far as he could take these cases, especially when it came to the classified documents case.
I mean, I think that today's action is really not that surprising to, those of us that know the system. And I think that this really was the inevitable, result. The idea of trying to push through until January 20th is not really going to get you anywhere, because ultimately he is the president-elect. He will be the president in January. And so, constitutionally, he can't be tried. So what are you really doing? You're not going to get this case, to trial before January. So, dismissing at this point makes a lot more sense and gives them the opportunity to kind of, clean things up and get out of the way.
So let's look first at the classified documents case, because you and I spent a lot of time thinking and talking about this during the investigation. Just to bring our listeners up to speed, Trump was indicted last summer, and then it got dismissed several months before the election by the presiding judge in that case, Aileen Cannon, who ruled that Jack Smith was illegally appointed as special counsel. The Justice Department chafed at that ruling and really wanted to appeal it to the 11th Circuit, but now Smith is having to withdraw that challenge. And so I have a two-part question here, which is, number one, why do you think DOJ told Smith that he could not try to continue with the appeal against Trump? Because that's just the appeal. They were trying to get rid of this judgment from Aileen Cannon that he was improperly appointed because it would cause a problem with the special counsel statute, or the lack of a special counsel statute going forward. And B, what is the actual legal effect of the decision to drop the appeal? I mean, it's not binding on anyone, but could you talk a little bit about the legal effects as well?
Sure. So this was also something that was necessary to dismiss because, while you're correct that he's trying to overturn a finding that he was illegally appointed, the reality is, legally, he's trying to reinstate a criminal prosecution of a president. And so that's why, the appeal is not, the appeal of, this ruling. It's still United States versus Donald Trump. And so you require, Trump's to have his lawyers there to oppose the appeal and everything else. So, under the same constitutional reasoning as to why the January 6th case had to be dismissed, they really didn't have a choice. This had to go as well. Now, the legal effects of that, I think, are somewhat significant because you're right. It's not binding case law on anybody. It's a persuasive, U.S. District Court case, but no other court is required to follow that. But certainly, if anybody else is going to challenge the appointment of a special counsel, they can use this decision and kind of show it in opposition to some other decisions as a way of raising the issue in another case. Where it does become binding, and this is kind of a narrow issue, is there is now going to be a final judgment that Jack Smith individually was illegally appointed. And that's something that, is never going to be overturned. I do think that the decision is interesting because if you really pay attention to Judge Cannon's ruling here, what she does is she kind of takes the legislative history of there was a special counsel statute, Congress failed to renew it, and then DOJ was kind of doing their own thing after that. And so while you could certainly argue as to both sides whether that should or should not happen, ultimately Judge Cannon's ruling was kind of aimed at the legislature to take this back to Congress and say, hey, there was a statute, it expired. You guys should take a look at whether we want to create a new special counsel statute. Take the other one and reauthorize it, or based on the experiences of the past several years, do they want to craft a new special counsel statute? Because certainly for conflict issues, having a special counsel makes sense, but having this ambiguity over how it gets implemented is not helpful. So I think that this really goes back to me, to Congress, to say, okay, fix this and come out with a clear special counsel statute so we don't have this issue going forward.
Just on that point, though, because if you cast your mind back to Judge Cannon's opinion, there was a lot of ink spilled about whether or not Jack Smith was Senate confirmed and whether he was acting as a principal officer. Correct. And I guess the one difference in the documents case with that special counsel, as opposed to all the other special counsels like Robert Hur or Mueller or whoever, Robert Hur, for instance, was a Senate confirmed DOJ official. The one difference with Jack Smith was he just came from The Hague and he was never Senate confirmed for anything. Under your reading of the opinion, would it be fine, maybe in this incoming Trump DOJ or for future DOJs, for the department to use special counsels so long as they are already Senate confirmed, whether they're acting U.S. attorneys or former U.S. attorneys or whatever, to use Senate confirmed officials? Can you get around the special counsel statute issue that way?
Oh, absolutely. I mean, that was really the crux of the issue, is that you have somebody making decisions and doing things that is ordinarily a position that's required to be Senate confirmed. And you got to remember, for the vast majority of these cases, if you have a situation where there's a U.S. attorney's office that's conflicted, say, there's a case in the D.C. U.S. attorney's office is conflicted because one of the parties worked there or is related to the U.S. attorney or something like that, they're just going to cross-designate the Maryland U.S. attorney or the Eastern District of Virginia U.S. attorney to come in and take over that case. And so that's the kind of thing that happens. It's never a problem because you're just having somebody else who's already Senate confirmed, take over that position. Same thing with Durham, when he was the Delaware U.S. attorney. And so really that's kind of the difference, is that Merrick Garland just kind of plucked this guy out of Europe and put him in this position without any oversight whatsoever from Congress or from the Senate. And so you can either use sitting U.S. attorneys as special counsels, or you could probably name a special counsel and then send the name over to the Senate to get them to give the green light. Because what makes it different here, where you have to get somebody from outside the department, is where the entire DOJ is conflicted, and that's kind of the difference. If the U.S. attorney is conflicted, you just use the next U.S. attorney. But if the attorney general and the entire DOJ is conflicted, that's kind of where you need to get somebody from the outside. And then if you're going to give them that kind of power, to render that independent judgment, you should get that Senate confirmation done. And that's the kind of thing that the old statute provided for, but not having that statute doesn't really give any guidance.
Let's also look at the 2020 election case, because that was the other case that was that the special counsel moved to dismiss today. This was a case, again, just to give the background, pending before U.S. District Judge Tanya Chuk in Washington, and it was explained in the motion that in this case, he was ordered by DOJ, essentially by the DOJ's Office of Legal Counsel, the internal legal advice board, if you will, for the department, that he had to drop the case and they had to treat the president-elect as though he was the current sitting president. I guess, was there any real need to do this now? I mean, could it have come later? I mean, I guess it's kind of a moot point at this point, but it always seemed that case was destined either to be narrowed down further as a result of the Supreme Court's immunity decision, or just dismissed entirely once Trump took office. It always struck me that was the case that Jack Smith might have the biggest problems with.
Sure. I mean, doing it now versus later, it's a matter of judicial economy. Why, since everybody knows what's going to happen in January, what's the point of wasting resources continuing a case that is going to be dismissed? And I think that from the judge's perspective, the judge probably would have been a little bit annoyed had they not done this, and had they said, okay, well, we want to continue to litigate this. We want to have motion practice and have motions about narrowing an indictment that we all know is going to be dismissed. It's a total waste of time. And so I think that's the decision to dismiss it now, it just makes sense because and ultimately I think that the judge could have gotten annoyed with it and said, why is this, why are you still pretending like we're going forward with this case? There's nothing that's going to happen between now and January that's going to prevent him from becoming the president. This case is never going to trial.
Right. So that's all the past now. So what do you think will be the aftershocks of the special counsel cases? Because Todd Blanche, who you know well for various reasons, including your overlapping of him when you were on the Trump legal team, he's the nominee now to be the Deputy Attorney General. And there was certainly no love lost between Trump legal and the special counsel team. So what comes next from a DAG's office run by Todd Blanche, do you think?
Well, first of all, Todd Blanche was selected for that position when Matt Gaetz was the nominee for the Attorney General. And the Attorney General nominee is the one who gets to choose, with the president, who is going to be their deputy. So that's really, that is very much in doubt at this point of whether Pam Bondi even wants him there, or whether she wants to install one of her own people. So I don't think that you can say, with any level of certainty that he's going to be at DOJ. I do think that there are certain elements of this case, and if somebody were to ask, me for my input from DOJ, there are certain elements with the manner in which these cases were brought, and I'm talking very specifically about the Mar-a-Lago case, of misconduct by the prosecutors, that I think is something that is worth looking at. And I do think it's something it makes sense to have the new DOJ, look into, for example, the witness tampering when they were, dangling a federal judgeship in front of the attorney for one of the witnesses.
Okay, so let's just give a little bit of context here, because we reported on that incident for The Guardian as well, which was basically Stanley Woodward, the lawyer for Walt Nauder, Trump's valet, who was charged as a co-defendant in the documents case for obstruction. He had a meeting with the top deputies on the special counsel's team, including Jay Bratt, who was running the Mar-a-Lago prosecution. And as the allegation goes, and as we reported it, there was this sense that he should turn his client, Walt Nauder, into a cooperating witness if Stanley Woodward, the lawyer, wanted his judicial application. He was trying to become a judge in DC Superior Court. If that application was going to get a favorable nod from DOJ, and that has been contested in multiple different ways. And for what it's worth, it was mentioned in open court before Judge Cannon, but that's the incident you're referring to.
Correct. And so that's something that I think that the new DOJ may want to look into, because, when it comes to all these claims about the weaponization of the Justice Department, I personally don't necessarily subscribe wholeheartedly to the idea of weaponization based on politics, so much as, in my experience, I find that prosecutors can be weaponized against anybody. And,
great defense lawyer of you to say.
Yeah. And so if you want to have, a department that has any credibility, you need to make sure that you're doing these things cleanly. And if you have people that are doing the wrong thing, you have to pull them out. And even if you're prosecuting somebody that's totally guilty, you still have to follow the rules. And so if a prosecutor is cutting corners, threatening witnesses, lawyers, doing things like that, the ends do not justify the means. And somebody who is doing that type of stuff in the department needs to be made an example of and held accountable, so that you put that down to the younger prosecutors of, this is not how you conduct business. And so if the Justice Department wants to have any credibility whatsoever, they have to root that kind of stuff out. Although, while certainly you have these highly, visible instances from the Trump case, I would not, make it limited to, let's only look at prosecutors who, mess things up in the Trump case. I would look across the board. How many other cases have we had that have been, completely upended through some form of prosecutorial misconduct or another? Look at the Fat Leonard cases, which is the largest bribery scheme in the history of the United States Navy, and snared many, many officers, senior officers. And every single one of those convictions was overturned because of prosecutorial misconduct by DOJ attorneys who failed to turn over exculpatory evidence. I think that that's also something that can be looked into. And that's not a political case. So
okay, but let's just focus on the Trump cases, because DOJ also looked at the Ted Stevens case, and a lot of change actually came out of that. There was,
right.
That was the senator in Alaska where prosecutors didn't turn over all the discovery material,
right.
And some people actually died by suicide in that case, and it prompted pretty broad reform over DOJ, or at least that was the idea. But specifically with a Trump cases after action report, which I think at this point is almost certain to occur, whether it's Todd Blanche or anyone else in the Deputy Attorney General's office. So what you're saying is,
Smith.
Right?
Smith still has to submit a report.
But in terms of the report looking at the report, or the investigation looking at the report, it sounds to me like you're saying, there are broad areas here that should be looked into. Whether it was the individual prosecutors, you testified before a grand jury. In that case, and you had your own complaints about your experience there, and then there was also a lot of the way that the case progressed before the chief judge in DC. So, is it your recommendation, I guess, as for whatever it's worth, is it your recommendation that all of that gets pulled up, or just some of it, or how broad or how narrow would you make it?
My recommendation is very broad. And it is broad to the extent of, you have to clean up this kind of behavior within the department. And if you restrict yourself, to just one incident, I think you're not doing a service. I think if you look at everything in the Trump cases, I think you're still looking too narrow. I think that the new DOJ should really take a broader view of everything that's going on, any allegation of prosecutorial misconduct, look at all of it. Not just not just the Trump cases, but across the board, because this is something that's institutional that needs to be fixed across the board. Because
are you not sure that sounds like a witch hunt?
It may have been used against Trump here. It gets used against everyday citizens every other day in every other courthouse.
Look, I understand what you're saying. I guess with Trump specifically, though, Trump has vowed vengeance. He has vowed retribution against Jack Smith and his team, and Jay Bratt. He has mentioned by name in Truth Social posts. Like, are you concerned though that if there was a kind of a concerted look at some of these guys, and it was done in a manner of seeking to get retribution, some of these guys might come into harm's way.
Justice should not be about retribution. Okay? We put people in jail to keep Americans safe, not because we're angry at them. And so if we're pursuing things out of a sense of retribution or vengeance, then that is in and of itself a miscarriage of justice. What we should be doing is investigating people who have done the wrong thing. And this is, again, why I'm saying it should be much broader than just the Trump cases. Because honestly, if they go through and they do a prosecutorial misconduct review, and the only people that they hold accountable are members of Jack Smith's team, that looks like political retribution as opposed to actual reform and change in the Justice Department, because it's not limited to Jack Smith's team. And so therefore, if you limit the accountability to Jack Smith's team, that is in and of itself a selective prosecution.
When you look back at all of this, I mean, and you were particularly involved, I think, maybe more so on the documents case than you were with all of the other cases that came before your desk. When you look at that, when you look back at it now, do you think that was a case that should have been brought?
The documents case, I don't think it should have been brought. I think that the documents case could have been handled very differently from the inception, because the reality is, and we wrote this in a letter to the to the intel committees in the House and the Senate. That case was born out of poor document handling procedures in the White House that span every single administration. Every single president, going back to Reagan, when they went through the boxes, they found a mixture of classified and unclassified documents. The difference is, every single president going back to Reagan, the National Archives, NARA, would rent a facility near where the president, the outgoing president, was moving, and because that's where the presidential library is going to be, and they would maintain control of all those documents. So as they have them in a converted bowling alley in Texas, for example, for Bush, or in a furniture store in Illinois for Barack Obama, as they're going through these boxes, every single one of them, they found a mixture of classified and unclassified documents. They pull the classified documents, put them in a skiff. For Trump, they didn't get a facility like that. Instead, all of them went to Mar-a-Lago. And the day that he was moving out, and the NARA director was looking at the TV, and he said, I was very concerned because I saw those boxes sitting out on the driveway, and I knew that they contained presidential records. No. He knew, based on 40 years of data, that they contained classified documents because of the document handling procedures in the White House, and he didn't speak about it. He didn't say a single word. He let it go to his house. And then there are so many different off-ramps that they could have taken at any stage. He could have called up the president right there and said, hey, sir, I have concerns about these boxes. Can we put them in a NARA facility? Which, by the way,
okay, but can I just say, they did do that, right? There was repeated efforts to get these documents back, and there was a grand jury subpoena, and just based on the prima facie evidence here, there was at least some attempt to make sure that not all the documents went back.
So first of all, none of those attempts happened when they knew the boxes were going to Mar-a-Lago. They waited until they were already in place. Second of all, there's a way to make that type of approach, and there's a way not to. Okay, if you send someone a grand jury subpoena, that is basically a piece of paper saying, we're looking for classified documents in your house, and if we find them, we're going to put you in jail. Okay? Here's a different way. What if they instead sent down
that's not quite that. It's the subpoena is if you just give them back to us, and we're not even getting into active production doctrine here, but
it's a grand jury subpoena. A grand jury subpoena says we are investigating criminal activity, and we are looking for evidence of criminal activity, and we want you to give this to us because the grand jury function is not document recovery. The grand jury's function is investigation for prosecution. So a grand jury subpoena, it can't be interpreted any other way to any experienced criminal lawyer other than we're looking for evidence to put you in jail. Okay? The other way that they could have done it is they could have sent down a couple of investigators from the Director of National Intelligence to say, hey, sir, we've seen this in the past. We want to make sure that, that there's no documents, in your boxes. Would you mind if we worked with you? In which case he would have said yes. They didn't do that. From
Well, they
day
did
one,
come back. They
led
did
by
come
Jay
down.
Bratt, they used heavy-handed tactics to try to manufacture this whole case that never was needed. It was never needed.
If he had just complied with the subpoena, is there not an argument that all the rest of it wouldn't have resulted in the way that it did? If he had just given everything back when he got that subpoena, that was the second time DOJ was down at Mar-a-Lago, because the first time, they came down and we reported on in real time how, Evan Corcoran, then Trump's lawyer, didn't want to show them inside the storage room, but then Trump was like, no, it's okay, you can go see, and they looked at the book. So that was the second time they came down. They must have known, Evan and Trump, they must have known that this was coming down the pike, no?
If they had given all the documents back, they would have had everything they needed to indict him. So, I mean, the idea that if he had just complied with the grand jury subpoena, they would not have indicted is a fiction. It's total fiction.
Okay, well, let's just get on to the final bit of news that dropped today, which is Trump's senior advisor, Boris Epstein, is reportedly facing internal scrutiny over lobbying Trump to nominate certain people for jobs in the second Trump admin in exchange for payment. First, can you talk a little bit about how influential Boris is with Trump? And second, in your opinion, just what is your reaction to the report?
So, my experience with Boris, he had kind of, placed himself as close as he could to the president and then done everything he could to make himself the single point of failure so that nobody else could really get close to him. And, I think over the course of years, he kind of worked his way into this position and, really tried to stop anybody else from having any direct contact, with the president, except through him. And so, reading the allegations that came out today, I'd like to say that they surprised me, but the reality is that they don't. They maybe surprised me with the scope and the brazenness of it, and the fact that he, really does believe that at this point he's gotten to the point where he really is untouchable. But I mean, I think that it was, very good, good work by the reporters that uncovered this, particularly John Solomon. And I think that he's identified a major national security risk.
For what it's worth, and we should just clarify, though, that you do represent Eric Greitens, who was, maybe clarify for me what the situation was. He submitted an affidavit or a memo saying that he had an unpleasant experience with Boris, and that Boris suggested he make a financial payment in return for something.
Correct. Yeah. So one of my longtime clients, the former governor of Missouri, Eric Greitens, Boris did approach him, asked him what he was thinking about doing in the next administration, and then pushed him to hire him as a consultant, and then also asked him who else would be looking to hire me as a consultant. So it was consistent with the rest of the pattern of what you read in that article, is that he was offering these consulting agreements to use essentially his position and access to the president, to try and push for appointments, for nominations, for things like that. It was something that made my client very uncomfortable. It was very obvious what he was asking for, and then when the transition team asked him to provide a statement, he sat down, he was interviewed, and he provided the statement.
But we should also clarify that it's not illegal to do that, and in fact, it's fairly commonplace in Washington for people close to a president to lobby on behalf of potential or prospective clients.
I'm going to disagree with your legal conclusion there.
Okay. What's the legal analysis, just quickly?
A personal lawyer for any powerful person who is then getting consulting fees on the side to try to influence their own client, to use their own legal position to exert influence. I think that is illegal. It certainly is, a violation of the ethical rules. I think that there's an honest services fraud argument to be made here. I do think that, based on what I've read, and I haven't sat down and gone through the statutes, but to simply say that there's that this is not illegal, it violates numerous ethical rules, and I believe that it could violate some criminal laws as well.
Although, again, just quickly, Todd is the personal lawyer as it currently stands. Todd Blanche is currently the personal lawyer of Trump, and technically speaking, Boris would be the general counsel to, it was originally the Trump campaign or Save America PAC, no?
It all depends. It's kind of, depending on the day, what Boris's position is. He always likes to talk about himself as the, personal attorney for Donald Trump, the House counsel to Donald Trump, whether he's part of the campaign or whatever. But he does have a ethical obligation to the individual client. And I think that he violated that if these allegations are true.
Understood. All right. Well, Tim, thanks for coming on. I really appreciate it.
All right. Thank you.
Highly Conflicted is produced by Politicon. I'm Hugo Lowell, a senior political correspondent at The Guardian. Special thanks to our guest today, Tim Parlatore.